Mr. Chairman, Inspector General Horowitz, I want to see if I can get you to help me a little bit. You have a background as a very distinguished prosecutor, if my memory serves me correctly.
I was a prosecutor. I'll leave it to others to decide how distinguished.
I think you were very distinguished. Why does law enforcement need informants?
They're critical to the effort to get into organized crime, drug rings, other organized criminal activity, because the best information is gathered from the inside of the crime families or structures.
Yeah, I remember trying to get some first grade and kindergarten teachers to help me in some of my drug prosecutions, but they didn't know anything about the drug ring, so sometimes you have to use people who are actually part of it. But there's a difference between someone working off charges and someone working for money.
Correct.
Help the jury understand why you need both and what the difference between the two is.
Well, on a defendant who's been arrested who wants to cooperate, the law, the sentencing guidelines, and policies in place incentivize cooperation as a way to work off a potential sentence. So judges are informed, and judges then decide what benefit value to give to the individual who cooperates, and that is in the form of a reduced sentence, or in some instances no jail sentence that they might otherwise have faced. For a non-defendant, whether it's a citizen who has not engaged in wrongdoing or someone who may be involved in wrongdoing but has never been charged, the payments are designed to incentivize them to report on information, provide information that there is oftentimes no other leverage to get, although, as I said earlier, for most individuals, if they see wrongdoing and it's public, the hope would be that they would come forward and report on it rather than need to be paid to do that.
Can you think of an example where you would use a paid informant to gather information that would be available via subpoena or search warrant?
Not off the top of my head as I sit here.
Do you recall the line of cases beginning with Giglio?
I do.
What's Giglio?
So Giglio and its progeny require prosecutors, the government, federal or state, to provide defendants with information that would tend to exculpate them, to allow the defense to argue they're not guilty, but also separately to impeach the credibility of government witnesses at trial proceedings or other court proceedings.
For instance, if we were to confer a benefit on a source, a confidential source, that would need to be disclosed to the defense attorney, the defense team.
Correct.
How do you do that with subsources?
That was our very serious concern, particularly if you don't even know who they are and you have no policies or controls in place to identify them or understand what their conduct they're engaged in.
It strikes me as a serious issue. Or you have that issue, or if there's no expectation of litigation, no expectation that a charge is ever going to be leveled or a prosecution's ever going to be undertaken, then maybe you don't have to worry about Giglio. Do you have a sense in looking at this whether or not arrest and prosecution were the ultimate objectives of the employment of some of these informants, or was it just simply information gathering?
Based on what we were told, our understanding was these were for the purposes of advancing criminal investigations. We did not go down the road and see who ultimately was arrested and what cases were brought, but it was very clear to us that these were to advance criminal drug investigations.
So if the objective is to one day wind up in a courtroom with charges, and hopefully a conviction, then how do you get around the use of subsources where you cannot meet your obligations under Giglio?
That was precisely our concern.
Do you still have that concern?
We do.
If you shared it with DEA, what did they do to assuage your conscience?
Well, that's one of the things we're waiting to hear back from next month in their first report following our September audit.
Would you let Chairman Chaffetz know what I have a world of respect for law enforcement, as I know you do too, but if the objective is an arrest and a successful prosecution and you have constitutional requirements under Brady and Giglio, I don't know how you do that with the use of subsources where the prosecutor either doesn't know or doesn't know enough. I don't know how you do that.
That's precisely our concern, and there were, I might add, several other areas where we were concerned as to whether what was going on in practice impacted and how it impacted the necessary constitutional disclosures that needed to be made to the defense about a wide variety of activity. We talked about the disability payments. It's not clear to us, in fact, it appears to us that that information, if those individuals ever ended up in court, wasn't widely known and therefore, in almost all likelihood, wouldn't have been fully disseminated. Other activities of tipsters and other limited use sources that resulted in criminal cases may or may not, unclear, but may be relevant to that decision, and there didn't seem to be a system in place for anybody to, in fact, make that assessment.
Well, I know I'm out of time, but in addition to making life very uncomfortable for prosecutors who have to appear before judges and explain why they didn't turn over certain information, you also run the risk of whatever convictions you gather being overturned because of a discovery abuse. So I hope that you get the answers to your questions, and that if you're able to, you'll share the results with Chairman Chaffetz.
Okay, before the gentleman yields